a medieval jury in action. She is standing inside a cold, echoing space, not a courtroom as we imagine it today, but the nave of a parish church, cleared of benches. In smaller villages, such hearings might take place in a manor hall or even a large barn. There is no raised platform, no lawyers, no spectacle, only the community, watching. Alice is young, a spinner by trade, working wool into thread. Honest work, respected work. For years, she has spun beside other women, exchanging gossip, sharing tools, known to everyone here since childhood. 2 days ago, a reeve came to her door. She was accused of stealing cloth, fine wool found near her home. She was told to appear before the community. Now she waits. She is shaking, not from the cold alone. Theft can mean hanging. 12 men step forward. They are not strangers. They are neighbors. They know her family. They know her reputation. They know the land, the quarrels, the grudges, the unspoken truths of this village. They are sworn, not to investigate, not to debate law, but to answer one question. Is Alice guilty, according to what we know to be true? Evidence is spoken. Rumors surface. The cloth was found, but no one saw her steal it. No one speaks of past dishonesty. The jurors withdraw briefly, then return. They acquitted her. Alice does not collapse. She does not cry. She simply breathes. Her life has been spared, not because the system was perfect, but because it was communal. She will still be punished. The king's officials distrust mercy. Because of her evil fame, suspicion without proof, she will be ordered to leave the realm. Exile, not death. But she will live. In another place, in much of continental Europe, her fate would likely have been sealed by ordeal, by torture, or by inquisitorial judgment. Guilt assumed, confession extracted, sentence imposed. Here, the jury stood between the crown and the noose. And that raises a question. How did England develop a system where ordinary people, not judges, not priests, not royal agents, could decide life and death? Why did English justice rely on a fixed number of jurors, again and again, across centuries? Why 12? Why did this system take such deep root in England, surviving kings, conquests, and revolutions, while elsewhere it never truly did? And was this system born from mercy, or from something far colder? Control, efficiency, and the need to govern without constant violence. To answer that, we need to step back, far before Alice, far before 1280, and trace how England arrived at one of the most enduring institutions in legal history: the 12-person jury. Early origins and influences. The tradition of a 12-member jury has deep and likely multi-layered roots. Some historians have pointed to biblical symbolism as one possible influence. According to an early Welsh tradition, a ruler named Morgan of Glamorgan, known as the Generous, established jury trials in the early 8th century, deliberately choosing the number 12 in imitation of Christ and the 12 apostles. In this account, Morgan declared that just as Christ and his apostles would one day judge the world, earthly tribunals should consist of the king and 12 wise men. Whether legend or practice, this tradition suggests an early and conscious association between the number 12 and moral authority. Other influences came not from symbolism, but from lived legal practice. In classical Rome, juries in the modern sense did not exist, yet Roman courts sometimes relied on large panels of citizens to hear cases. These assemblies could number in the dozens, but they were instruments of civic participation rather than community testimony. The English jury, as it later developed, owed far less to Rome than to the legal cultures of Northern Europe. In Anglo-Saxon and Scandinavian societies, law was intensely participatory. Disputes were resolved in public assemblies where free men gathered to speak, accuse, defend, and swear oaths. In the regions of England shaped by Scandinavian settlement, particularly the Danelaw, this culture of collective judgment was especially strong. Viking communities convened at assemblies to resolve disputes, and Danish towns in England appointed groups of 12 hereditary lawmen who acted as local legal authorities. These men did not investigate evidence. They preserved legal memory and communal norms. As one historian observed, such Norse law committees of freemen made England unusually receptive to the later growth of the jury system, which the Normans would formalize rather than invent. Even legend reflects this continuity. A Danish tradition recorded by Saxo Grammaticus claimed that the 8th century king Ragnar Lodbrok established a tribunal of 12 assessors. Another indication that the idea of judgment by a fixed group of 12 was already familiar in Germanic custom. On the European continent, Frankish and Carolingian rulers developed practices that further foreshadowed the jury. Charlemagne and his successors appointed sworn judgment finders in each county to sit in local courts and assist in determining cases, a reform documented in the 9th century. These men were chosen for their standing and knowledge, not for legal training. Carolingian kings also made extensive use of the inquest, a procedure in which royal agents summoned local men and placed them under oath to answer questions about land, rights, and crimes. This method assumed that truth resided in collective local knowledge rather than in confession alone. Significantly, some Carolingian rulers began to question older methods of proof. In 829, Emperor Louis the Pious abolished the ordeal of cold water in his domains, signaling a preference for sworn testimony over supernatural tests. This did not end the ordeal everywhere, but it revealed an emerging tension between divine proof and human judgment. Trial by ordeal itself deserves careful placement in this story. Ordeal was not a Scandinavian invention, nor uniquely Anglo-Saxon. It was a Christian legal practice, widely used across medieval Europe, rooted in late Roman and early Christian belief that God would intervene physically to reveal truth. In England, ordeals of hot iron, boiling water, and cold water were employed primarily for serious crimes, especially when testimony conflicted or reputation was unclear. Detailed rules governed these rituals. The accused fasted, prayers were said, clergy supervised the test, and wounds were examined days later for signs of divine judgment. Ordeal was thus not arbitrary violence, but a structured appeal to God when human certainty failed. In England, this system persisted until the early 13th century, when ecclesiastical support for the ordeal collapsed and alternative forms of proof became necessary. By the 11th century, the practice of summoning 12 local men to answer questions under oath was already familiar in Normandy, in Danelaw, and in regions governed by Welsh law. Biblical symbolism, Germanic communal judgment, and Frankish administrative inquiry had begun to overlap. All of these traditions grappled with the same fundamental problem. How could truth be established in a world without forensic evidence, professional judges, or investigative police? Medieval England answered this not through a single method, but through a sequence of mechanisms: sworn speech, communal accusation, ordeal and combat as divine tests, and gradually, the independent verdict of 12 men drawn from the community itself. The number mattered, but so did the force that made judgment credible. That force was the oath, spoken publicly, bound to reputation, and reinforced by the belief that false words carried both social and spiritual consequences. Oath-taking, binding truth through the soul. From the earliest Anglo-Saxon period through the High Middle Ages, truth in English law was not primarily established through interrogation or written evidence, but through oath-bound speech. The oath was not a procedural formality, it was a religious act, binding the swearer before God and placing their eternal fate at risk if they lied. The authority of oath-taking depended on unanimity. A sworn body that could not agree was treated as having failed to uncover the truth. Law preferred delay, repetition, or escalation over compromise. In both Anglo-Saxon and later medieval England, jurors and witnesses swore corporeal oaths. They physically touched or kissed sacred objects, most often the Gospels, relics of saints, or a consecrated altar. The physical act mattered. The oath was not abstract. False swearing was believed to invite divine punishment, either in this life or the next. To swear falsely was not merely to mislead a court. It was perjury against God. This culture of oath truth explains how early English legal systems could function without professional investigators. The law assumed that most people feared spiritual consequences more than temporal punishment. Even when that assumption failed, it exerted enormous social force. A man who broke an oath risked not only damnation, but permanent loss of reputation, exclusion from the community, and legal disability. As juries evolved, so did their oaths. Early jurors swore to tell what they already knew, acting as witnesses to local facts. Over time, jurors shifted from being sources of information to evaluators of competing claims. Their oath changed accordingly, binding them to judge faithfully and according to conscience rather than personal knowledge. The religious force of the oath, however, remained intact. Medieval society was not naive about the possibility of false oaths, corruption, or pressure. That is precisely why English law developed formal mechanisms to punish dishonest jurors and witnesses. Severe penalties for perjury existed, as did the extraordinary procedure of attaint, by which a jury suspected of delivering a false verdict could itself be tried and punished. These remedies demonstrate that oath-taking was not symbolic. It was foundational, enforceable, and taken with grave seriousness. Anglo-Saxon precursors, from oath-taking to jury. Before the Norman conquest of 1066, Anglo-Saxon England did not possess juries in the modern sense, but it did employ communal justice mechanisms that served as clear precursors. Saxon courts relied on compurgation and trial by ordeal rather than verdicts delivered by a deliberating panel of peers. In a typical Anglo-Saxon lawsuit, after an accusation was raised in the 100 court, the court did not determine guilt directly. Instead, it determined which mode of proof would apply. For less serious accusations, the defendant might be permitted to swear an oath of innocence and support it with oath helpers drawn from the community. These oath helpers were men of good standing who swore to the credibility of the accused's claim. In many cases, the required number was 12. If the accused assembled the required oath helpers and performed the ritual correctly, reciting the oath without hesitation, error, or contradiction, the claim of innocence stood. A failure of the ritual, such as inconsistent wording, a misstatement, or an oath helper's refusal or error, was taken as a sign that the oath lacked divine support and therefore implied guilt. This practice reveals the early legal importance of the number 12. A defendant of good reputation might require 12 men to affirm his credibility, foreshadowing the later role of 12 jurors in confirming guilt or innocence. When communal oaths failed or agreement could not be reached, English law turned to divine judgment. Ordeal and, later, combat were not alternatives to justice but extensions of it, invoked when human knowledge reached its limits. For more serious or ambiguous cases, ordeal was employed. The accused might be required to carry red-hot iron, immerse a hand in boiling water, or undergo the ordeal of cold water. These rituals were Christian in form and belief. Clergy supervised them, prayers were said, and the outcome was interpreted as God's judgment. Ordeal was not a Norman innovation. It was already well established in Anglo-Saxon England as a method of proof when human testimony was deemed insufficient. Late in the Anglo-Saxon period, however, a more jury-like institution began to appear. Around 997, King Ethelred issued a law for the Danelaw requiring 12 leading thanes of each 100, together with the royal reeve, to swear on holy relics that they would accuse no innocent person and conceal no guilty one. These men were charged with identifying suspects and initiating prosecution. In effect, this created a sworn body of 12 local men tasked with presenting crime, an early form of the jury of presentment, later known as the grand jury. These bodies were self-informing. They were expected to rely on their own knowledge of local affairs rather than evidence presented at trial. Similar practices appear in the laws of Knut and in traditions attributed to Edward the Confessor, indicating that by the early 11th century, England was already accustomed to assembling groups of 12 reputable men to swear to truth in matters of law. By the late Anglo-Saxon period, then, England employed collective sworn accusation as a standard legal mechanism. Groups of local men, often 12, were required to swear whether crimes had occurred and who was suspected. This was not trial by jury, as it later developed, but it established the essential principle. Truth could be declared collectively, under oath, by members of the community. Norman conquest and the introduction of formal inquests. The Norman conquest of 1066 accelerated and reshaped the development of the English jury system by importing Norman Frankish practices of royal inquest and judicial combat. William the Conqueror did not invent these tools, but he combined them with existing English customs of oath-taking and communal knowledge to create a more centralized system of control. Under Norman rule, sworn local juries became instruments of governance. William used them not primarily to decide guilt, but to gather authoritative information. The most famous example is the Domesday Survey of 1086, a kingdom-wide inquiry into landholding, value, and obligation. Royal commissioners traveled county by county, holding inquiries in each shire court. The basic unit of inquiry was the 100, and the return for each 100 was sworn to by 12 local men, drawn deliberately from both English and Norman populations. These jurors were placed under oath to answer the king's questions truthfully, relying on local knowledge rather than formal evidence. These doomsday jurors were not judges in the modern sense. They acted as sworn witnesses to fact. Yet the format established a powerful precedent. 12 men, bound by oath, speaking collectively on behalf of their community. William's insistence on mixed English and Norman juries also served a political purpose. It lent legitimacy to Norman authority, while simultaneously subordinating local knowledge to royal inquiry. At the same time, the Norman conquest introduced a second, more overtly coercive form of proof into English law: trial by combat. Judicial battle was a Norman import rooted in continental Germanic custom. It was understood as a form of divine judgment, invoked when testimony conflicted or when honor, land, or status was at stake. In such cases, truth was believed to emerge through physical victory, sanctioned by God. Trial by combat was used primarily in disputes between free men, especially over land, inheritance, and accusations that could not be resolved through oath or witness testimony. Unlike ordeal, which was often applied to the unfree or socially marginal, combat was a privilege of status. It reinforced aristocratic values of martial honor while placing legal outcomes literally in the hands of the strong. Thus, by the late 11th century, English law operated with multiple overlapping mechanisms of truth. Sworn inquests gathered information for the crown. Oath-taking and compurgation resolved lesser disputes. Ordeal remained a Christian ritual of proof for serious crimes. And combat stood as the ultimate test when elite claims collided. These systems were not contradictory, they coexisted. What the Normans brought was not a single method of judgment, but a hierarchy of proofs, increasingly tied to royal authority. Inquests expanded the crown's knowledge. Combat and ordeal preserved older ideas of divine judgment. Together, they created a legal landscape in which the king's justice reached deeper into local life than ever before. This was the world inherited by the Angevin kings of the 12th century, a world in which truth could be sworn, fought for, or tested by God. The reforms of Henry II would not abolish these practices at once, but they would begin to reorder them, placing sworn inquiry above violence and spectacle, and pushing English law decisively towards the jury system as we recognize it today. Assizes, combat, and Henry II's land reforms. In civil disputes over land, especially freehold property, Henry introduced the Grand Assize and Petty Assizes. The term assize does not mean a jury itself. It refers to a royal procedure or framework, a standardized way of resolving certain disputes using the authority of the crown and sworn local men. Rather than have two parties fight in a trial by combat to settle who owned land, Henry allowed them to opt for an assize jury, a panel of 12 free and lawful men from the locality who would investigate the facts and pronounce who had the rightful claim. Before these reforms, disputes over land ownership could be settled by judicial battle, a formalized fight in which victory was treated as divine judgment. This was dangerous, socially destabilizing, and arbitrary. Henry II introduced what became known as the Grand Assize, which allowed a disputant to choose the judgment of 12 local men, often knights instead of combat. These men swore to determine who had the better legal right to the land, based on local knowledge and inquiry. This was revolutionary for two reasons. It replaced violence with sworn investigation, and it reinforced the idea that truth could be established by collective human judgment, not physical endurance or divine spectacle. These land juries were early versions of trial juries, although at the time they delivered a sworn verdict based on their local knowledge, not on evidence presented by lawyers as we have it today. The two-stage truth system: jury accusation followed by ordeal. In criminal law, Henry II's reforms, notably the Assize of Clarendon in 1166, established the grand jury system. The Assize of Clarendon ordered that in each county, 12 lawful men of every 100 and 4 lawful men of every village be sworn to report under oath all local persons accused or suspected of serious crimes, such as robbery, murder, theft, etc. These jurors of presentment would accuse or present individuals who would then be arrested and put to the ordeal as trial. In essence, Henry II instituted a two-stage process: a jury of accusation or grand jury followed by trial by ordeal to determine guilt. The chances of conviction under this system were actually lower than under pure royal fiat. The juries first had to make a collective accusation, and even if accused, the person might pass the ordeal and go free. Henry's motive for these reforms was to extend royal justice and undermine feudal local courts. By commanding local juries to cooperate with itinerant royal justices, the justices in air, Henry could enforce the king's law uniformly. The Assize of Clarendon explicitly states that the 12 jurors of each 104 of each village must tell the truth regarding who in their community were robbers or criminals. Those named by the jury were seized by the sheriff, and if royal justices were not immediately available, held for trial or sent to the water ordeal later. This system effectively made the community itself responsible for policing. An accused had the lawful judgment of his peers, at least to initiate the case. This system did not invent ordeal. Ordeals had existed in Anglo-Saxon England long before the Normans, embedded in Christian ritual and supervised by clergy. What Henry II's reforms did was link the ordeal procedurally to jury accusation, making the ordeal the default proof stage for felony after sworn presentment. Crucially, this means that ordeal was not a free-floating superstition in English law. It was a tightly regulated step, triggered only after collective oath-based accusation. The system assumed that jury accusation filtered cases, while the ordeal served as divine confirmation or rejection of human suspicion. Henry II's reforms mark a critical point in the evolution of the jury. By the late 12th century, the idea of 12 local men sworn to speak truth was firmly entrenched. These juries at first acted as accusers and witnesses, rather than neutral arbiters. A criminal jury's verdict still often relied on whether the accused could clear himself by oath or ordeal. But this was all about to change in the early 13th century. How long did the ordeal really dominate? Contrary to popular impression, ordeal did not dominate English justice for centuries. While ordeals existed earlier and continued in local or customary contexts, their mandatory role in royal criminal procedure was intense, but relatively brief. The systematic use of ordeal following jury presentment belongs mainly to the period from the mid-12th century to the early 13th century. After 1215, when clerical participation in ordeals ceased, the system collapsed rapidly. Within a few years, English courts did not replace ordeal with torture or inquisitorial interrogation. Instead, they expanded the role of the jury itself, allowing juries to decide guilt or innocence directly. This is a critical turning point. England did not move from ordeal to interrogation, but from ordeal to jury verdict. The collapse of the ordeal was not gradual. It was abrupt, institutional, and irreversible. The shift from ordeal to jury trial. A major turning point came in 1215. In that year, the Church's condemnation of trial by ordeal greatly boosted trial by jury in England. In the same year, Magna Carta reinforced the principle that judgment should follow lawful procedure rather than royal discretion. While it did not establish jury trial, it strengthened the legal environment in which jury verdicts could replace ordeal. During the Fourth Lateran Council in 1215, the Catholic Church decreed that clergy must no longer participate in ordeals. Priests were forbidden from blessing the iron, the water, or the ritual itself. Since clerical involvement was essential to the legitimacy of the ordeal, the practice collapsed almost immediately. In England, where the legal system had been depending on ordeals to determine guilt in serious crimes, an immediate alternative was needed. The solution was to use the already existing juries not just to accuse, but also to decide guilt. English juries under the Assizes began deciding guilt as well as providing accusations once ordeals collapsed. This transition happened swiftly after 1215. By around 1220, the petit jury or trial jury was established in criminal cases to deliver verdicts in lieu of an ordeal. In short, trial by jury replaced trial by ordeal. England was uniquely positioned to make this transition because it already possessed sworn juries accustomed to speaking under oath. What changed was not the institution, but its function. Other European countries took a different path. Most adopted judge-led inquisitorial trials, often using torture to obtain confessions once ordeals were gone. England, however, maintained an accusatorial system, now with the jury of 12 at its center, which would have profound effects on the fairness of justice. Did this spare England the inquisitorial path taken by Europe? Yes, with an important qualification. After the collapse of Ordeal across Europe, legal systems faced the same problem: how to establish guilt without divine signs. Many continental jurisdictions adopted judge-led inquisitorial procedure, drawing on Roman canon law. This system emphasized written depositions, professional judges, and confession as the highest form of proof, often extracted under torture. England took a different route. Because England already possessed sworn presentment juries, a deeply rooted culture of oath-bound communal truth, and a royal system accustomed to using local men to establish facts, it was able to replace ordeal with jury determination rather than interrogation. This does not mean English justice was gentle or modern. Punishments were harsh, and errors were common. But it does mean that England largely avoided institutionalized torture as a routine method of proof, relying instead on collective judgment by sworn peers. This divergence becomes increasingly clear from the 13th century onward. In the same year that the Fourth Lateran Council ended clerical participation in ordeals, King John was compelled by his barons to seal Magna Carta. One of its most famous clauses declared that no free man could be punished except by the lawful judgment of his peers or by the law of the land. In 1215, judgment of peers likely referred to judgment within one's social estate, such as barons judging barons. Yet over time, this principle was interpreted more broadly as a guarantee of judgment through lawful communal process. The requirement that punishment pass through the judgment of equals placed a barrier between the accused and arbitrary royal power, a principle that later generations would associate with the jury itself. In the decades after 1215, jury trials became standard in English royal courts. By the 1230s, the typical procedure for felony was two-stage. First, a grand jury of 12 men accused or indicted a suspect. Then a second group of 12 local men, the trial jury, was sworn to determine guilt or innocence. These early trial juries were not neutral listeners in the modern sense. They were often drawn from the same community as the accused and were expected to bring their own knowledge of the facts, the people, and local reputation. In the early 13th century, the same men who served on the accusing jury could also serve on the trial jury, carrying their suspicions forward. Only later, by the mid-14th century, was this practice forbidden in order to reduce bias. Verdicts had to be unanimous. A divided jury was treated as having failed to uncover the truth. Throughout the 13th century, jury decisions often rested on what contemporaries called common fame, reputation, rumor, and collective belief. Jurors sometimes convicted without eyewitness testimony, but they also acquitted defendants they believed were wrongly accused. Records show that acquittals were common, sometimes to the frustration of royal authorities, who complained of overly lenient or perverse juries. To control this independence, English law retained the writ of attaint, allowing a jury suspected of delivering a false verdict to be tried and punished by another jury. Though used rarely, its existence underscores how seriously jury verdicts were taken. By the late 13th century, trial by 12 peers had fully replaced ordeal and combat in England for criminal cases and many civil disputes. This placed England on a sharply different legal path from continental Europe, where inquisitorial procedure and judicial torture became common in the 14th and 15th centuries. While later commentators may overstate the contrast, There is real significance in the fact that an Englishman could not be convicted of a serious crime without the consent of 12 fellow subjects, a comparatively humane safeguard for its time. Later, medieval developments, independence and impartiality. Over the 14th and 15th centuries, the jury evolved from a self-informing body of witnesses into the neutral fact-finder we know today. Medieval juries were originally expected to come to court, already knowing something of the facts, or to actively investigate the matter themselves. This system deliberately shifted the burden of fact-finding onto local communities, sparing the Crown the cost and complexity of investigation, while embedding legal responsibility at the village level. For example, if a theft occurred in a village, the jurors at trial might simply be the villagers who knew what happened. Outside witnesses were optional. Often, the jurors were themselves the witnesses. However, as commerce expanded and cases grew more complex, especially in towns where jurors might not personally know all parties, the practice of presenting evidence to the jury in court became more common. By the 15th century, a gradual but decisive shift can be observed. From at least the 15th century onward, jurors began to rely upon what was presented in court as the basis for their decision, rather than solely on their own prior knowledge. In other words, juries started listening to witnesses and arguments in court and deliberating on that evidence, more like a modern jury. A legal commentary notes, "Initially, jurors were more like witnesses in that they were picked because they knew something about the facts at issue. By the 1500s, jurors no longer decided cases based on their own knowledge, but on the information they received in court." This was a fundamental change toward impartiality. Several developments encouraged this. The 1440s to 1500s saw the rise of witness testimony under oath, apart from jurors, and the presence of lawyers arguing cases, especially in civil disputes. Juries were increasingly kept ignorant of a case beforehand to ensure fairness. In 1353, as mentioned, a law forbade those who had served on the accusing jury or grand jury from serving on the trial jury, reinforcing the idea that trial jurors should not have preformed opinions. By Tudor times, 16th century, it was understood that a juror should not have personal interest in the case, reinforcing the emerging ideal that verdicts should rest on judgment rather than familiarity. Indeed, a juror could be challenged and rejected if proven to hold bias or prior knowledge that would sway him improperly. Thus, over medieval and early modern centuries, the jury transformed into an impartial trier of fact. Yet the path was not always smooth. Medieval and early modern juries were not completely free. Judges and authorities did try to control them at times. In some periods, if the Crown felt a jury delivered a wrong verdict, the jurors could be fined or even imprisoned, a clear pressure on their independence. This happened, for example, in 1554, when Sir Nicholas Throckmorton was acquitted of treason by a London jury. Queen Mary's government was furious at the not guilty verdict. Nearly all the jurors were promptly jailed and fined for defying the prosecution's expectations. Such punishments, while irregular, sent a chilling message that a jury might suffer for refusing to convict. Despite this, courageous juries sometimes stood up for their belief in a defendant's innocence. Over time, public opinion came to regard juries as defenders of liberty against tyranny. The case revealed the unresolved tension between jury conscience and state power at a moment when the jury's independence was not yet secure. One landmark case underscored this principle. The Bushels case of 1670. Two Quakers, William Penn and William Mead, were on trial in London for unlawful assembly, essentially for preaching Quaker doctrine. The jury, led by Edward Bushel, repeatedly returned verdicts of not guilty, despite the judge's insistence that the men clearly violated the law. The infuriated judge detained the jurors, imprisoned them without food, water, heat, or light, saying, "I will have a positive verdict or you'll starve for it." The jurors refused to give in and never convicted the Quakers. The judge fined the jurors and kept them in jail, but Bushell sought a writ of habeas corpus. The higher court ruled that jurors cannot be punished for their verdict. Juries must be free to decide according to their conscience. This case decisively articulated the principle of jury independence in English law. A plaque at the Old Bailey Courthouse today commemorates Bushell and his fellow jurors' courage. After 1670, it became settled that while a judge may guide or open the eyes of jurors, he may not lead them by the nose. The jury's verdict, even if contrary to the judge's view, could not be punished. This was a crucial step in making juries a true bulwark of liberty. Throughout these centuries, one thing remained constant: the number 12. By at least the 1300s, the standard size of a trial jury was fixed at 12 members, and this endured in England for over 600 years of history thereafter. Juries of 12 were viewed as providing a cross-section of the community and enough collective wisdom to reach just decisions. In the words of Sir William Blackstone in the 1760s said, "The fact of an oppression must be examined and decided by 12 indifferent men. Only such a body could stand as the surest guardians of public justice." By this point, 12 no longer required symbolic justification. Tradition, procedure, and legal memory had fixed it in place. The unanimity of 12 was also traditionally required, as all 12 had to agree to convict, making it a high bar to punish someone, another protection for the accused. Other jury-like bodies sometimes used different numbers. For example, early grand juries could have 12 to 23 members, and certain civil juries in modern times have been smaller. But the 12 good men and true became the iconic image of the English jury. Notable cases and anecdotes across history. To illustrate how the jury system developed in practice and how it differed from other forms of justice, a few notable cases from different periods are especially revealing. Early use of 12 in land disputes, 1160s. In the decades after Henry II's reforms, disputes between knights over land that once would have been settled by trial by combat could instead be resolved by the Grand Assize. One party would request the assize, a royal writ would issue, and 12 knights from the locality would be summoned to swear who held the better right to the land. These 12 delivered a sworn recognition rather than fighting a duel. Contemporary writers observed that many landholders preferred this process to risking death or injury in judicial battle. Although individual names are often lost, royal records from the 11th 70s preserve dozens of such cases. One is described by the jurist Glanville, who explains how the sworn judgment of 12 men settled a contested matter without violence. John Lilburn's trial, 1649. In the aftermath of Civil War and Revolution, the radical pamphleteer John Lilburn, known as Freeborn John, was prosecuted for treason by the Commonwealth government. The political stakes were enormous. The new regime needed obedience, and public dissent was treated as a threat to order. Yet the jury refused to deliver the verdict the authorities expected. Despite intense pressure, Lilburn was acquitted. The courtroom erupted in celebration, and the verdict became a vivid example of how a jury could still block state power, even in an atmosphere of fear and political instability. The Trial of the Seven Bishops, 1688. When King James II attempted to force the public reading of his Declaration of Indulgence, 7 bishops petitioned against it and were charged with seditious libel. The prosecution's theory was straightforward. The petition had been published, and publication itself was framed as criminal defiance. But the jury did not accept that logic. It returned a verdict of not guilty, and the acquittal was celebrated across London. The case became one of the clearest demonstrations that juries could refuse to punish respected defendants simply because the Crown demanded it, reinforcing the jury's emerging role as a barrier against arbitrary power. Colonial America. The Zenger Trial. 1735. In New York, printer John Peter Zenger was prosecuted for seditious libel after publishing criticism of the royal governor. The judge instructed the jury that truth was irrelevant and that printing alone proved guilt. Zenger's lawyer appealed instead to the jurors' sense of justice. The jury acquitted him, effectively nullifying the law as applied. The verdict became famous as a defense of free expression and demonstrated the continuing power of juries to act as a check on authority. These cases show the jury at work across centuries, sometimes cautious, sometimes defiant, sometimes protective, but always inserting community judgment into the machinery of law. By contrast, in many parts of continental Europe, similar cases were decided without juries. A well-known example is the trial of Urbain Grandier in France in 1634, conducted entirely by judges and supported by forced confessions, ending in execution. In the same era in England, juries frequently acquitted defendants in witchcraft cases when evidence appeared unreliable. Such contrasts reinforced the English belief that jury trial, though imperfect, offered a tested and comparatively fair safeguard against injustice. By the 18th century, William Blackstone, the great commentator on English law, could describe trial by jury as the palladium of English liberty. By this he meant not that the system was ancient in an unchanged form, but that over many centuries it had been trusted, adapted, and preserved as a central protection against arbitrary power. Conclusion. From its complex origins, shaped by biblical symbolism, Germanic communal judgment, Carolingian inquiry, and Anglo-Saxon oath culture, the 12-person jury emerged in England as a central institution of justice. It evolved from groups of local men sworn to speak what they knew into panels expected to deliberate impartially on evidence presented in court. This transformation unfolded slowly, across centuries, and was driven less by abstract theory than by practical need: how to resolve disputes without constant violence, divine ordeal, or unchecked royal command. By the High Middle Ages, England had taken a distinctive legal path. While much of continental Europe moved toward judge-led inquisitorial systems that relied on written procedure and, eventually, torture to extract confessions, England expanded the role of the jury. Guilt or innocence increasingly depended on the unanimous judgment of 12 peers rather than on physical tests, coercion, or executive will. The result was not modern justice in any sentimental sense. Punishments remained severe, but it was a system that placed a meaningful barrier between the accused and absolute authority. Over time, the jury's role continued to evolve. Jurors ceased to act as witnesses and became evaluators of evidence. Rules developed to exclude bias, separate accusation from judgment, and protect jurors from punishment for unpopular verdicts. By the late medieval and early modern periods, the jury had become an independent decision-making body, capable at times of resisting political pressure and legal rigidity in the name of conscience. Throughout all these changes, one element endured: the number 12. By the 14th century, it had become fixed, not because of symbolism alone, but because practice, memory, and procedure had made it familiar and authoritative. 12 offered sufficient collective judgment, required unanimity, and embodied the idea that justice should rest in the hands of the community. The history of the 12-person jury is therefore not a straight march toward modern ideals, but a long process of adjustment, away from ordeal and spectacle toward deliberation and shared responsibility. No legal system is perfect, but the endurance of the jury across centuries reflects a persistent belief that truth is best sought not by force or decree, but through the considered judgment of one's peers. If you enjoyed this deep dive into how England built the jury system we still rely on today, subscribe for more historical narratives about medieval law, power, everyday life, and the hidden origins of modern institutions.